Hello everybody, I am Rusha Mukherjee, a student of Charlotte Law College and presently interning with LEXIS and Company. Today I am going to speak about the labor reforms that we saw in the past year. The labor law is actually a part of the concurrent list where the state and the center both can make laws. Earlier there were 40 plus labor laws. That was very confusing, and hence it was decided that all the labor laws will be divided into 4 codes. These 4 codes will actually be a summation of all the labor laws till today. Now, these were the Codes on Wages Act of 2019, and the last 3 were the Industrial Relations Code of 2020, the Code on Social Security of 2020, the Occupational Safety, Health and the Working Conditions, that too was of 2020. Now, these were very important laws because these had to be implemented in a very different way, and it also introduced certain reforms in the labor world. In the first instance, in the Code of Wages Act, it actually combined the Payment of Wages Act of 1936, the Minimum Wages Act of 1948, the Payment of Bonus Act, and also the Equal Remuneration Act. All these were taken together. Next, now the Industrial Trade Union Act and the Industrial Employment Standing Order Act, the Industrial Dispute Act, all these were actually brought under the second code, that is the Industrial Relations Code. Now, here the number of workers were increased. That is, earlier it was 100 workers and now it has become 300 workers. If there are 300 workers, then the holiday, pay day, workers classification all had to be mentioned specifically. Another thing that comes is if there has to be a closure, retrenchment or the layoff of any of these factories, then the permission or prior permission has to be taken. 14 days notice is very much necessary before any strike by the laborers, and this notice will be valid only for 60 days. Changes for trade unions were also brought. Like if a factory has more than one trade unions, then if anyone has to be subjected as the sole negotiating union, then it should have 51% of the employees as its members. But then earlier it was 75%. Now the Code on Social Security 2020 combined 9 labor laws. It was the unorganized plus organized, both were taken together. The comprehensive social security of the workers were also seen of the unorganized sector. The government had to formulate welfare schemes, any of the welfare schemes that will be for the betterment of the laborers who are present. Now, the employee's definition was also increased. Now, employee does not only mean what it meant earlier. Now it would include the film workers, the interstate migrant workers, the platform workers, each and everybody will be involved in it. Next was that the gratuity period was also modified. The gratuity period undergone a change, like it was for the working people, the working journalists, it was changed from 5 years to 3 years. Now the central government has also been given the power that it can reduce the employers or the employees' contribution under the provident or the state's employment funds only during the situation of pandemic, endemic or any national emergency whatsoever. Now last one, that is what we get about the ultimate last labor law, that becomes the occupational health, safety and working conditions, that is actually dependent upon the health, safety and the very good working conditions of the people. It replaced the 9 old labor laws relating to this, like the Factories Act, the Contract Labor Act and the health safety, everything is taken care about. It has expanded the meaning of factory. Like now it is not told that it has to be a hazardous place or something like that. Only if there are more than 20 people who are using power, it can be termed as a factory. And maximum work period has to be 8 hours per day. and a record of the interstate migration migrants have to be maintained, because that can be helpful for any benefits that are given to them. For that, a portal can also be made. Now again, the working has to be, if the working fees is greater than 18,000, then he can be an interstate migrant also. And all these reforms that we see, all these reforms that we have been incorporating in these 4 reforms of the labor laws is actually aimed at the business development, the growth of the industries, the growth of the factories and whatsoever. However, the effectivity of these four labor laws, that has been the summation of the 40 labor laws that were earlier, is not so easy. And only time will speak up that whether these labor laws are actually being able to get its ultimate destination and actually protecting or guaranteeing the same things or the same benefits as it is expected to do. That's all for today. Goodbye and thank you.